So I normally like to start a webinar with a frightening story about the issue at hand. And my frightening story about this is I joined a company a few years ago and as financial director, and the owner said to me, she painted quite a rosy picture of the place, but they'd got rid of their previous financial director. And when I asked her why, she said, "Oh, that'll be the industrial tribunal." And I said, "Oh, what was that then?" And she said, "Well, what happened was he dismissed someone without any process, which is bad enough in itself. But then what happened was they got taken to an industrial tribunal and he hid the paperwork and then didn't attend. And obviously they were found as being unfairly dismissed. There was a big award, and it was the maximum award available at the time, and he hid that as well." So so I came in after him to sort of sweep up the remains, so to speak, and I think from memory it was about £120,000. I know that the maximum award has been reduced since then, and plus of course there was a load of costs. But I think the message is that I've got just enough knowledge of HR to say that I don't know enough about HR to do anything, and that you really must follow a procedure. So let's just quickly go through a little bit of housekeeping then. So we are recording. Like I say, I'll be making the recording available afterwards, and we'll send out the slide deck to everyone. Now, we've enabled Q&A. I'm hoping that it's working. If you've got any questions, please do add them to the chat panel. I think your microphones are automatically muted, but if they're not, please do mute them, just for everyone else's comfort. So Peter then kindly agreed to work with us. I'll just stop sharing that. Kindly agreed to work with us in putting together this webinar. He comes highly recommended. I've done a little bit of work with him, and I've got to say, I tend to ask a lot of stupid, repetitive questions, and Peter is without doubt the most patient person I know. So I have absolutely no hesitation in recommending him to you all. So perhaps Peter, do you want to see if you're able to share your slides, and then we can launch into the presentation?
Thank you. Okay, so my name is Peter Appleby. Stuart very kindly introduced me before. I'm a HR professional, been doing the job longer than I care to remember, over 25 years, in quite a few different sectors. I'm a chartered fellow of the CIPD, which is the highest level of qualification you can get. And my role is as a director of 186 HR Limited, which is a company I set up after leaving my last employed role. I specialise in difficult issues regarding people, whether that's changing behaviours, parting company, or anything else. So that's probably enough about me. Thank you very much for attending today. I appreciate it's not the most popular subject, but hopefully, as Stuart's example shows, it is a necessary evil, is HR. I know most people wouldn't choose to spend their time doing it, so good for you. Stuart, if you wouldn't mind moving to slide 2, I'll be grateful. So today, we're going to discuss 3 main things. Might contractors actually be deemed to be employees by HMRC? Why you should act quickly if an employee isn't right for you? And are you too busy to get the basics right? If there's time, and I'm sure there will be, there'll be a Q&A towards the end. And if we do need to fill any other time, I've got some relevant and interesting tribunal cases, if anybody wants to go through them, that will bring things into focus, really. And I've tried to choose subjects throughout this presentation that are relevant both to employees and contractors, because I know a lot of you will have contractors mainly. Okay. So would you mind moving to slide 3, please, Stuart? So this is all about the contractors issue. You may have read about this. There's been a really high-profile case in the last couple of years. It's actually quite a tricky issue for employers, this, and there's quite tricky legal stuff regarding it. But it is something that needs to be borne in mind by especially smaller employers. Because if you get it wrong, there won't be much sympathy from the HMRC. You can expect a backdated tax bill, a fine from them, but also individuals may well claim for holiday pay, sick pay, pension contributions, some of that stretching back several years. So it can be quite expensive. So when might somebody be classed as an employee then, rather than a self-employed contractor? That would be if the organisation controls what the individual does. They're likely to issue all equipment and require them to work at specified times. And so a lot of smaller companies I speak to say, aha, my contractors don't do that really, so I'm safe. But there's a bigger risk here because a little known type of work, employee is a bigger risk. It's whether the individual may be classed as a worker. Now, a worker in terms of employment status is someone that sits in between being self-employed as a contractor and being an employee. Most SMEs I speak to haven't heard of a worker, but although they're not a full employee, workers are entitled to holiday pay, sick pay, and if they want to join, a pension scheme. The easiest way to explain what a worker is to look at this famous case that I alluded to a minute ago, and that is regarding Uber. So you'll certainly have seen something around this. With the Uber case, several drivers claimed that because Uber control their work, they're actually employees or workers, and therefore they're entitled to backdated sick pay, holiday pay, and some of them wanted pension contributions as well. They took Uber to a tribunal, and Uber says, no, you're self-employed. You use your own car. You're clearly self-employed. Uber took it through all 4 stages of the employment tribunal system, right up to the Supreme Court, which is the highest court in the land, and they lost at every stage. So that legal action actually cost them a fortune, but that sort of pales into insignificance, really, when you look at the cost of the legal action next to the cost of having to compensate all those people that were now classed as workers, not self-employed, for their sick pay, holiday pay, and in some cases, pension contributions. I say some cases pension contributions because you can only claim if your earnings are over £6,240. I'd like to talk a little bit more, if you don't mind, about why the Supreme Court and the other areas of the tribunal came to that decision, because I think we can quite easily adapt it to those contractors doing inventories for you. So if you wouldn't mind going to slide 4, please, Stuart, I'd be grateful. Right, so the Supreme Court decision, it helps us to advise companies better because it really highlighted what the definition of a worker is, because not many people know. On the slide there, I've put what section of the Employment Rights Act it is, but that's obviously that's just detail, which TFL heads like me like the detail, but I'll spare you from most of the detail. You have to be a certain age, by the way, to appreciate the TFL head joke. The Supreme Court was very clear that some individuals who were deemed to be self-employed aren't the workers. And they emphasised 5 aspects which justified that conclusion. And these are on the screen now. So whilst they're not employees, the claimants were working for and under contracts with Uber. And as you will all know, a contract doesn't have to be written. So even if it's an implied contract, they were under a contract. So those 5 points are, the first one is where a ride is booked through the Uber app, Uber sets the fare. Drivers are not permitted to charge more than the fare. It is therefore Uber that dictates how much drivers are paid for the work they do, not the individual. Now, I've never done an inventory, but I suspect that that wording could just as easily be transferred to the role of a contractor carrying out inventories. Is that right, Stuart, would you say?
Sorry, Pete, I had to switch my mic on again. Yes, in many cases it is, because the associates will often be given a price for the job, and that's all they can charge.
Thank you. Exactly. So it would be the associate that controls that element. So the second bullet point is the contract terms on which drivers perform their services are imposed by Uber, and drivers have no say in them. And I would imagine that you devised a contract that your inventory contractors work to. The third point, once a driver is logged onto the Uber app, the driver's choice about whether to accept requests for rides is constrained by the company. So I'm sure that some of your contractors can refuse to do an inventory, maybe it's 50 miles away or something, but generally, I suspect that you have a fair bit of control over that. The fourth point is that Uber exercises significant control over the way in which drivers deliver their services, including by the use of a rating system. Any driver who fails to maintain the average rating, etc., etc. Now, with regard to this, I would imagine, again, you use fairly standard inventory forms. So I think that will be deemed that you decide how an inventory is carried out when you go to a particular house or the premises. And any feedback afterwards will be delivered to you rather than the individual contractor. So again, I would say that similar to Uber, you would be controlling that. The final bullet point is that Uber restricts communications between passenger and driver to the minimum necessary to perform the particular trip. So again, I would imagine that when a customer or client is arranging any inventory, they contact you. If they have any issues about it, they contact you. If after the inventory they have any queries, again, I would imagine they contact you. So I'm not saying definitely that all of your contractors are workers. What I am saying is you may want to just think about this issue, take some advice, and make a decision. The good news is that whereas most business owners aren't aware of the status of a worker, individuals are even less aware of it. So most organizations can, for want of a better expression, get away with this because the workers, if they are workers, will never be any the wiser. But I would always say forewarned is forearmed. If you wish to take that risk, clearly that's up to you. But as long as you know the situation, and therefore if it does raise its head, you can manage it appropriately and not tell them to get stuffed because they're chancing their arm and never darken your doorstep again, because they may have a claim. So there may be some questions on that in the Q&A that we do later, but the whole purpose of including that was just to get your thought processes going to see, do I need to look further into that? And if you do, whether it's through me or FSD or whoever else, then I've done my job if you decide you may want to look into it more. We haven't got time to go through all of the different wheres and wherefores, and it won't be relevant to a lot of you either, so I'll leave it there as far as the details are concerned. Would you mind moving to slide 5, please, Stuart? So this is more to do with employees rather than contractors. So it's why you should act quickly if an employee isn't right for you. So I spent a fair bit of time last week researching quotes from Angela Rayner, because she's the one that was bringing in this legislation under the Employment Rights Bill. It's a crown and glory. It's what she's been talking about for absolutely years. Obviously, that now turns out to be a waste of time. Fortunately, none of this involves Peter Mandelson, so I haven't researched any quotes from him. Problem is, though, the bill is likely, even without Angela Rayner, the bill is likely to progress through Parliament. The government has been very clear that it's totally committed to it. despite all of the feedback from the CBI and various other employers' bodies saying, A, it's a massive burden, B, it's going to cost billions, and C, it's the wrong time to be doing this kind of thing to employers because we're on our knees. But with it being a flagship policy, it's likely to come through. And it's likely to start coming through in October. So if you have an employee with, say, a poor performance record, too much absence, or one that just isn't suitable and you'd really like to part company with them, you just haven't got around to doing it yet. Although the AIIC codes specify various 3 process steps of warnings and improvement plans before you can safely dismiss somebody, there's ways around that without having to be unfair to people. So I would advise you to start looking at that soon if you do have an employee that really doesn't fit with your organisation. Due to any reason, there doesn't have to be a slam dunk as far as bad performance is concerned. There's ways and means. But there's also, very importantly to me, and I'm sure to you too, there's ways and means of doing it fairly. At present, if an individual with less than 2 years service tries to put in a claim for you dismissing them, they would be barred from doing so because they have to have at least that 2 years service for unfair dismissal. That's not the case for discrimination. You can claim discrimination at any point in the employment relationship. You can even claim it before you're employed, believe it or not. But the 2-year thing doesn't count for discrimination, but it does for unfair dismissal. The problem employers and the tribunal system are going to have is that there are a lot of people that get dismissed before their 2-year anniversary. Although it often takes employers quite some time to realise the individual doesn't fit, it's normally within 2 years. And now all of those individuals will be able to chance their arm in a tribunal, which will obviously lead to a massive backlog with the tribunal system, but it will also lead to big headaches for employers, especially smaller employers that don't have a HR function to fight it. The system's going to be overwhelmed, and a lot of people will chance their arm, even in just the hope of getting what we call a nuisance payment of a couple of £1,000s to go away, basically. So the government has said, well, no, don't worry, because we're going to keep a probation period system in place, although they've not given us any details of that. But in my experience, most people pass the probation, even though the employer has doubts about them. And it takes quite some time before you bite the bullet and want to dismiss them. So it may well be that their proposals regarding the probationary period are reasonable and we can work around them. And you may have 6 months in order to make that decision. So not the end of the world, but my experience of employers is that very few people do get dismissed within that probationary period. Once the individual is past the probation period, and by the way, if you don't tell them they've failed, they are deemed to have passed. It's normally a 6 months process for probation. Once they are deemed to have passed that probation, it's likely to take at least 3 months while you progress through a series of 3 warnings before you can terminate a contract for an individual. And anyone that's ever been through that will tell you it's an absolute nightmare having someone in the business for 3 months while you manage their performance or their absence, or you try and get them to change their behaviour. It's so difficult. So if you have some employees with less than 2 years service, you know they're not really right for you, I would advise you to act quickly on that. At least have a conversation with someone you trust that knows about HR before this comes in next month. I've never advocate acting unfairly, as I said before, but there are ways and means. Otherwise, it's going to be quite a lengthy process that's going to be awful for everyone concerned, including the individual, because I probably shouldn't say this as HR, but we all know that the kindest thing to do often is to put your arm around someone and say to them, listen, it's not working out, is it? Let's agree something and then, part ways and shake hands. Unfortunately, those days went 20 or 30 years ago. And so to be safe, you have to follow these policies that are very uncomfortable for all concerned. Right. Again, it may well be that you have some specifics you want to talk about regarding difficult employees in the Q&A, but that's probably enough for now, because again, all I want to achieve with it is to say to people, if you've got one of those people, talk to me, Stuart, FSB, or someone else that you trust to decide whether you want to act before then. So slide 6 then, if you don't mind, Stuart, is about getting the basics right. Because you're busy people, the last thing you want to be doing is HR stuff. I fully understand that. Like I say, it's a necessary evil, but nobody likes doing it. The first employment law course I went on 25 years ago was actually run by an employment judge. And I never forget, one of the first things he said, it was, follow the law, follow your policy, act reasonably, and you will win every case that comes before my tribunal. That's all I look for. It's very simple. Obviously, it's not simple, but that has stood the test of time. Like I said, I've been attending tribunals for 25 years now, and again, you win if you follow those 3 principles: follow the law, act reasonably, and follow your policy. As a small employer, a lot of you won't have an employee handbook. A lot of you won't have policies, and that's absolutely fine. You're not required to by law. All I would say is, if one of these issues rears its head, whether that's a redundancy, somebody having too much absence, somebody having a disciplinary due to either performance or conduct, then speak to either AIIC or me or the FSB and follow the CIPD recommended policies. They're available quite widespread. I actually subscribe to a system called HR Inform, which is run by the CIPD. Oh, sorry, CIPD is the Chartered Institute of Personnel and Development, by the way. It's the body for people who do HR. So I subscribe to that. So I always have the most up-to-date policies, letters, contracts, etc. So if something like this happens, I would advise you to just at that point say to the individual, right, we're going to follow a policy regarding your performance or your absence or redundancy, and we're going to use a CIPD recommended one. Here it is. And then contact me or someone else and work to that policy at the time, rather than paying someone £1,000 to put an employee handbook together that will gather dust on your shelf and probably out of date by the time you use it. That would be my recommendation. So what basics are we talking about then? For those people that you employ, it used to be that you had 45 days to issue a contract to people. That's not the case anymore. People must have a contract on day 1 or a statement of main terms of employment, which is just a light version of a contract. It doesn't need to be War and Peace. It doesn't need to be 15 pages long, but contracts should be issued on or before day 1. And it's just such an easy hit for a litigious individual, because if that doesn't happen and they take you to a tribunal, they can claim 4 weeks pay just for that breach of a statutory right. It's a no-brainer really. So if you have employees that don't have a contract, I would get one in pretty quick if I were you. Obviously, immigration is quite a big issue at the moment. I don't know whether you've seen the penalties for employing somebody that's not entitled to work in the UK. They're absolutely huge. If you employ an illegal worker, you can get charged £45,000 for one illegal worker. Also, any worker, even if you have a UK employee, it's a legal requirement for you to check the passport personally, not a picture, and take a copy of that to show that you have checked that they have the right to work in the UK. Again, it's an easy hit for any kind of worker to complain that you didn't do that. So it takes 30 seconds, but again, it's about getting the basics right. If you find that you want to employ somebody that doesn't hold a UK passport, obviously There's so many people in the UK that don't have a UK passport. That's fine, that's great, but they must have the right to work here, and they will have documentation that's quite obvious whether they can work or not. But you do need to check it. You need to keep a copy on file just in case it's challenged, because if you don't have it, you'll be deemed not to have checked, and it could be a massive fine for that. Right, so they are the three main areas that I was going to talk about today. If you have 5 or 10 minutes, 5 minutes extra to spare, there's three employment tribunal cases that are probably relevant to everybody, but I'm conscious of the time, and if you want to move straight on to Q&A, that's absolutely fine. So if we're going to go through those ET cases, that's slide 7, Stuart. But if not, we can go straight on to Q&A. I'll be guided by you.
Gotcha. Well, I think we've got 5 minutes. I know we started a bit late, and if people do have to drop off, that's fine. We're going to be distributing the recording afterwards.
Okay, so, thank you, Stu. I'll go through them, like I said, the maximum 5 minutes, really. But three probably, and these are relevant to contractors as well as employees, which is why I picked them. Right, so the first one, a contractor was doing some work in a government department, and there was a power cut. Please accept my apologies, by the way. With these examples, in one I have to swear, and in others I have to say things that are not what you would say in a normal open conversation. So, but I'm just quoting what happened. So it was there was a government department, contractor working in it. They had a power cut, the lights went out, and a black employee was walking to a contractor who joked, "Oh, it's a good job you're wearing a white shirt, because I wouldn't have seen you otherwise." Clearly, the employee got quite upset about that, because they viewed it was a comment about their race, and they went to a tribunal. The important point there is it's not the contractor that was sued. It was both, they sued both the government department and also the contractor's company, because it's up to the contractor to make sure that their employees are trained sufficiently not to make comments like that. And the employee won quite a lot of money from the contractor's organisation and also the government department, because both of those were required to protect the employee and ensure they weren't subjected to comments like that. So the takeaway from that obviously is, even if you only have contractors, what they say and do on your behalf is something that you need to be conscious of and manage. Now, I won't go on too much about that, because I know that that comes under vicarious liability, and I know that Stuart has another session for you on that at some point. So the next case I'd like to talk about, and this is one where I have to swear, I'm really sorry. If Stuart rather didn't swear, please do that or something now.
Well, I think we're all adults, Peter.
Right, thank you. Well, this was a case from a building site where one worker said to another, "Fuck off, you Welsh bastard." And the Welshman took it to a tribunal for both unfair dismissal, because he said, "I can't work in a place that allows that kind of language," and also for situations of race, because nationality is part of race. The tribunal judge heard all the evidence and said, "Well, I am not going to uphold the case for unfair dismissal, because although I don't agree with it, swearing on a building site and telling people to do that and calling people that B word is, I would imagine, quite normal. I wish it would stop, but in the way things are at the moment, I can't find unfair dismissal just for that, because I suspect it's quite common, and you'd have to sack half the builders in the country. But because you related the word bastard to Welsh, that is clear race discrimination, and awarded £3,000 to the Welshman simply for putting Welsh in front of the name calling. So again, that is something that both employers and those with contractors just need to be aware of with the language that people are going to use. Now, the final example, again, is relevant to both sets, whether it's contractors or employees. And this is probably the most famous HR case of all time, this one, because it's on every single course I've ever been on. It involves a swimming pool, a council-run swimming pool, and a lifeguard saw a lady doing lengths at the far end of the pool, and she was a very attractive lady, he thought, and he said to his mate some lewd comments about the lady doing lengths. That lady didn't hear the comments, but there was a lady taking a rest very close to the lifeguard station who did overhear the comments. So the comments were about that other lady, not her. But the other lady did her lengths, got showered, went home. Nobody has a clue who she is because she didn't hear it. No one ever told her about it. And so she never made a complaint. Common sense would tell you that that's the end of the matter. However, because that was the comment about women, ladies, the lady who overheard the comments felt that that was sexual harassment as far as she was concerned because it was demeaning to women and she was a woman. She raised a claim and won significant compensation from the council. Now, clearly there's consequences there for the lifeguard. If you do employ people, if they say something like that, then you need to follow disciplinary procedure. But the main point of talking about this example is if a comment is overheard or if somebody's told about that comment, they can raise a claim for discrimination. It doesn't have to be aimed at the individual. So if a racial comment is made from one person to another, both white say, but a person from a different ethnic background overhears or is told about it at a future point, they could raise a claim because that was a comment that is abusive to them and their race, or their sex, or their disability. And you never know who is going to be offended by what, do you? Because everyone is brought up with different values. Everyone has different thresholds to what they find acceptable and what they find offensive. So some people might be very happy to tell a sexist joke, but are very, very sensitive towards any racial comments. You just don't know. So again, the message there is just to be aware of any language that shouldn't be there in a workplace and do something about it. Here's the plug. If anybody does want, sorry about this, it's brazen. If anybody does want any training in that regard, I've agreed with Stuart and Lloyd that my banter and behaviour in the workplace online course, which is 40 minutes long, you can have it for half price. Please don't feel obliged to do it. I'm sure you won't feel obliged to do it, but I'm just saying it's there if you want it. Half price. Roll up, roll up. That's the end of everything that I prepared to say, Stuart. I hope that's been of use to people. So maybe we could move towards the Q&A session.
Yeah, that's great. Thank you very much, Peter. And one of the things I would say to people is go and have a look at Peter's website, 186hr.co.uk, because there's some really good case studies on there. And, you know, one of the things about HR that never ceases to amaze me is that a lot of the time it isn't necessarily practical common sense, such as your example about a person who's a subject of a remark not hearing it, but there's still being a claim there. So I think that's really useful. Now, hopefully, people will be able to either raise their hands or put a note in the Q&A, and we can have some questions. Please post away. I'm going to ask a question. I'm going to use the prerogative of the chair. You said their policies. Again, give you another war story. we had somebody that misused a company phone going back a while, and we wanted to take disciplinary action. And the very first question the HR manager asked me was, "Where's your mobile phone policy?" And we didn't have one. So my question is, what would you say are the sort of bare minimum or the first steps, policies that a small business should have in place?
That's a really good question, Stuart, because, well, in HR land where I live, there should be policies on pretty much everything that could possibly go wrong. But that's not going to happen in most SMEs. And so anything where the risks are stronger. So yes, if somebody is allowed to use their mobile at work, this needs to be that. Something on confidentiality. Something on what happens if you leave the organisation with regards to what you can and can't say, whether you can contact customers. Because if one of your contractors decides to set up on their own, hopefully you'll have a policy that means they can't take all your customers with them. I don't think it's essential to have, like I said in the presentation, disciplinary grievance, etc., because you can. That's not breaking a policy. That is using a policy to sort an issue out. So yeah, phones, confidentiality, I would say, probably absence and reporting of absence if you have employees, because it's so annoying when somebody doesn't phone in and you don't even know they're not working. The first you know is your customers calling them up. But then if you don't have a policy that says they need to call you by 9 o'clock in the morning, you can't say, well, you broke that policy. All you can do is tell them this is what my requirements are. And then if they do it in future, then you can actually take that forward, because you don't need a policy if you can show that they have breached a reasonable management request. So if they have not phoned on time and you say, right, you need to phone on time in future, not doing it in future means they've breached a reasonable management request. Oh, okay. So you can rescue it.
Ah, right. That makes sense. That's a new one on me. Yeah. Right. Has anybody got any further questions, any points for Peter? I particularly like you've got a post on your website about somebody sighing at the wrong moment.
Yes. Yeah.
Which was discriminatory. Is it discriminatory? It was
because because that's how people take it. The thing about discrimination is you can make a comment or a sigh or a facial expression, and if somebody complains about it, you can say, oh, grow up, for goodness sake. But legally, if they're offended, and they can try and raise a complaint. It's not up to anybody else to decide what someone can be offended by.
Okay, I'm with you.
But spurious claims will get kicked out by a judge. Judges can be really quite strict about people being overly sensitive. I'll give you an example of when one wasn't overly sensitive, according to a judge. This was in a supermarket. A supervisor said to an 18-year-old female that she was a stroppy little teenager because she was acting up. That teenager got £2,000 for age discrimination. Age discrimination can happen for younger people as well as older people.
Right, I got you. So we've got a question from Sally. A lot of us work with typists. So essentially what happens is we go into a property, we chat away into a dictaphone or into our phones. We send that off to, a lot of the times it's India. It is in my case. We send it off to India. They type stuff and they send it back to us. A lot of people have got local typists. So would a typist be categorized as employed?
I would say it depends on the nature of that employment. So if you send it to a consultancy or an organization that does that, then clearly she'll be an employee, or he or she will be an employee of that company. But if it's an individual that you have met somewhere and decided, actually, that would be great for me, I'm going to use them as my typist, and you give them work or they do the work and then you pay them, they are highly likely to be either an employee or a worker.
Yeah, that makes sense. I mean, I think most of them will probably work for external organisations. They probably wouldn't fall into the worker category because they decide how much they charge. Essentially, we ask them to do a thing and they decide how they do it. And if they get it wrong, they have to put it right. We don't put it right. So fingers crossed on that one. Question from Paul. So if you've got someone who you agree will work 2 days a week for you and will carry out only work for you on those days for a set amount of hours, would they need to be employed? And if so, what would they be entitled to? Holidays, sick, etc.
That sounds to me like a part-time worker or a part-time employee, depending on the things that we went through in the presentation. Obviously, I won't repeat them all, and you're sending this around later, but I would check those slides and I'd do it again. I often use the Uber example as a test for this. So I would ask yourself the questions about those 5 principles in the Uber slide to see whether that person would be a worker or an employee. But if especially if they are fixed days and you control all of the inventories and you pay them, I think that's either a worker or an employee. And if they are a worker or an employee, if they're an employee, then yes, sick pay, holiday pay, and if they earn over £6,240 a year pension, that's an automatic right. It has to happen. If they're a worker, then sickness and holiday pay, yes, but with regards to the pension, they have to request it.
Yeah, that makes sense. And I think one thing that I was taught, putting my accountant's hat on here, is that you do have to remember that employment law is different from tax law. So in some cases, if you are not an employee for tax, you are an employee for employment law. So you do have to be really careful that when you're taking advice, do be clear about what advice you're getting. Because, for tax purposes, you could quite easily be a self-employed person. But for employment law, like the Uber example, you could easily be categorized as a worker. And a question from Lloyd then, is the share code system for right to work the same as right to rent?
I'm not familiar with the right to rent one. Do you basically check the passport and any visa to ensure that the person is entitled to live in the UK?
Yes.
And to rent a house?
Yeah.
It will be pretty much identical, but clearly it will be around being able to work, not live or rent.
Yeah. So for those that haven't come across it before, if you're an overseas worker, now that we're out of the EU, you'll have a visa, and on the visa it will have normally there'll be a little phrase about what you're allowed to do when you're here. And a typical one, we've got a lady from South America, and it says on her visa, allowed to work in the UK as long as it's not paid professional sports. So she's not allowed to be a professional footballer, but she is allowed to do inventories, which is helpful for me.
Do you mind if I add something to the foreign worker thing? Becoming a sponsor for someone that isn't at present authorised to work in the UK is an absolute nightmare. So if you do come across somebody that doesn't already have the right to work, it's a big job. You have to actually become a government approved sponsor of foreign nationals in order to employ that person.
Oh, okay. Yeah.
So you have to be really quite determined that that person's right for you, because it's a very laborious process. But your local council can help you with it.
Okay, yeah, that's helpful. Okay, I think we are at the end of the Q&A now. I don't think we've got any more questions. If you do have a burning question that you haven't answered, or something comes to you in the middle of the night, if you do want to send me an email, chair@AIIC.co.uk, I'm happy to pass that on to Peter. And what I'll do is, as I did with the last webinar, I'll include the answers in the follow-up email when that goes out with your recording link. Similarly, so we've got, as I said earlier, we've got other webinars planned for the future. But if you think of a topic which you think will be usefully covered by us, and we can get a guest speaker on, then please do let us know. Again, same email address, send me an email with your thoughts, what topics would be good, and I'm happy to try and organise that for you. Okay, so it only remains for me to say thank you everyone for struggling through the technical difficulties at the start. And thank you so much, Peter, for giving up your time to come along and explain these. I've learned things, and I've been on the fringes of HR for years. So that's been really helpful for me. And I'm going to go now and check my share drive and just check what policies and procedures I've got in place, because I'm a little bit concerned now. When I send out the slide deck, I will include some further resources. It includes Peter's website. You can always check out the AIIC website, which is really useful. They've got lots of free information. I would always advocate becoming a member of the FSB, the Federation of Small Business, if you are a small business owner, because they have got a lot of free resources and you are covered quite a lot on their insurance schemes. So have a little look at that. But the links for those will be sent out in the post-webinar email. Okay, well, thank you very much, everybody. I'm going to call the event to a close, and hopefully we'll see you in the next event.
Thank you. Take care.
Guys, cheers.